Good morning, everyone. Welcome to the RWK Goodman webinar on the Employment Rights Bill. Thank you for joining us today. The session is being recorded, just to let you know. So if you want to watch this again later or share with a colleague, you can do. So my name is Richard White. I'm a partner, head up the employment team at RWK Goodman, and I'm joined today by three of my colleagues, Adrian Henderson, Kate Benefer, and Kirsty Swan. And each of the speakers are going to take you through some different key provisions from this new Employment Rights Bill and what they might mean for you as employers and HR teams. So where are we at the moment? Where have we got to with the bill? Well, as we know, back in July, 17th of July, we had the King's Speech, which set out the background to the bill and why it was being introduced. Some of the more significant things that were mentioned at the time were things like the increase in the number of people working in sort of less secure forms of employment, with over 1 million people working under 0 hours contracts. And the bill wants to provide some more security and predictability for those workers, extending protection for workers for day one rights, which apparently is going to encourage workers to switch jobs, which is associated with higher wages and productivity growth. It'll be interesting to see the higher wage point, bearing in mind the budget that we had about a month ago. And it also talked about things like industrial relations should be based around good faith negotiation and bargaining, which I think probably makes sense, but the devil will be in the detail, as always, in terms of how that's going to be introduced. So those were some of the background reasons for it. And the government said it was going to introduce a bill within 100 days, which it did. So what is clear is that this is moving at great speed. What's not so clear was perhaps highlighted on Tuesday this week in the critical opinion that was issued by the Regulatory Policy Committee. Now the RPC is the independent regulatory scrutiny body of the UK government. And what it does is it assesses the quality of the evidence and analysis that is used to inform government policy and proposals. And what can I say about the critical opinion? Well, I guess it's quite critical, I suppose. In terms of the bill, the government introduced an overall impact assessment, and it also drew up 23 separate impact assessments, one covering each section of the bill. And the RPC has assessed 8 of those 23 impact assessments as not fit for purpose. Those include things like the day one unfair dismissal rights, the repeal of the 2016 trade union rules, the flexible working changes, harassment by third parties, and the introduction of a fair pay agreement, amongst others. So all of those things have been assessed by the Regulatory Policy Committee as having not fit for purpose impact assessments. So to give you an example, and this is available through a quick Google search. In terms of day one employment rights, the impact assessment that the government drew up, the first thing it needs to show is the reason or the rationale for needing to legislate in the first place. So why are we doing it? And what the RPC said was the data the government has relied on the incidences of dismissal of people under 2 years service is not robust. So there's no robust data that they're looking at. And there needs to be further discussion of the existence and extent of the problem that they're trying to address. So the impact assessment doesn't even set out what the problem actually is. Also, the impact assessment refers to equity, so treating people fairly, but it doesn't address the fact that long-standing employees may not be feeling fairly treated if employees then on day one get the same rights as they have after they've been there for 2 years or more. So there's no proper rationale at the moment for needing to introduce changes and day one rights. Second, once you've identified a reason to legislate, you have to look at the different options. And what the impact assessment does is it looks at 2 options. It looks at do nothing and keep the qualifying period at 2 years, or introduce day one employment rights. It kind of dismisses any other options in between. And it doesn't assess whether reducing the qualifying period, for example, from 2 years to 12 months, whether that would actually appropriately address and rebalance the rights and protections of workers. It just doesn't cover that at all. And finally, the impact assessment doesn't properly justify why they are going with the option of day one rights that's in the bill. And part of the reason for that is because it hasn't considered any other options properly, and therefore it can't really justify the option of day one rights. So what normally happens is the Regulatory Policy Committee get to look at this before any proposal is announced, before any draft legislation is drawn up, so that that legislation can be well informed. That hasn't happened here. It's happened the other way round. So what appears to have happened in a sense is the parts of the manifesto have been cut and pasted into the Employment Rights Bill, and then the consultation and the consideration of that is happening afterwards, and happening quite quickly. So as we probably know, there is consultation going on at the moment where businesses and individuals have the opportunity to feed into the proposed changes in the bill. There's also changes already. So as of yesterday, the government tabled some amendments to the Employment Rights Bill, a couple of which are actually quite significant and are going to be picked up in today's talk. So already we've seen some changes, which is quite quick. Currently, the bill is going through the committee phase in the House of Commons, and then there'll be the reporting stage by the 21st of January. But I wonder, with the things like the RPC, critical opinion, and with the fact that they're already changing the bill at quite an early stage, whether we're likely to see probably some further changes as we go through the process. And what's actually put into legislation may have some tweaks from where we currently are, because what's clear is it hasn't been thought through, and that leads to bad legislation generally. Okay, so there's just some thoughts from me as to where we currently are and the fact that we may see some more changes. What are we going to cover today? We could just move forward a couple of slides to today's agenda. We've got a fairly packed agenda. So Adrian, Kate, and Kirsty are going to take you through unfair dismissal day one rights, 0 hours contracts, family-friendly provisions, flexible working, harassment, SSP, fire and rehire, and collective consultation. Now, normally, any one of those subjects would be a talk in itself, but we still don't have lots and lots of detail on what's going to be in the legislation. We have some more detail than we had a couple of months ago, so we're able to discuss some of those provisions with you, points with you today. As we go through the session, please do pop any questions you've got in the Q&A box. And if they're quick questions, we'll try and answer them as we go. If they're a bit more involved, we will try and get to them at the end if we have some time to talk about the Q&A at the end of the session. So before I hand over to my colleague Adrian to take you through unfair dismissal rights, I would just ask us, we're going to have a quick poll. You're really grateful if everybody, once the poll is launched, could answer these really quick questions just to give us a little flavour of what you are thinking about and what your organisation is facing at the moment and your worries about the Employment Rights Bill. So hopefully you can all see the poll. Just spend a minute answering those questions and then we'll have a little look at the results. Oh, interesting. I can already see some 50-50s on some of the answers. We'll give it another 30 seconds. So just give us a little bit of an overview of where you are at the moment in terms of your various things around 0 hours contracts and dismissal and re-engagement and policies. Okay, we haven't quite got everybody's answers in, but I think we've got a lot. So Andrew, grateful if you could end the poll and just give us share the results, please. So what have we got? Do you currently use 0 hours contracts? 50-50. So we've got quite a lot of people on the call who use 0 hours contracts. Have you ever used dismissal and re-engagement as a way of changing terms and conditions? Quite a lot of you not, but still 11% have. That could get a lot harder in future. A future changes to employment contracts? Quite a lot of you, yes. I think that might be a necessity when we see exactly what's going to be in the legislation. Day one, a lot of you not necessarily offering at the moment, or a lot of organisations not offering paternity or parental leave from day one. And then sexual harassment, have you carried out risk assessments? That's pretty good. Quite a lot of organisations have. Quite a lot of you haven't yet. That is something that you do need to do in relation to the preventative duty that's already here. Have you implemented reasonable steps to prevent sexual harassment? That's a bit divided too. And do you see third-party harassment as a potential risk for your organisation? Quite a few of you saying yes, and some of you unsure. So that's certainly an area which we can talk about as we go through. So, having had a quick look through those, I'm sure each of our speakers can pick up some of the relevant points from that. I will hand over to my colleague, Adrian.
Thanks, Richard. That's great. Good morning, everyone. I am going to spend the next few minutes talking to you about probably the most significant headline issue related to the Employment Rights Bill, and that is the main point around the government's intention to extend employment rights to a larger proportion of the workforce, and that is the unfair dismissal day one rights. Now, I said this is one of the most significant headlines from the proposed legislation, because this is the one which has probably raised most questions from our clients, and also probably caused a fair bit of anxiety amongst managers and HR professionals concerning what exactly this means for new hires, and how does this affect things like the ability of employers to effectively have some form of probation on new employers. So the long-standing policy of the Labour Party has been to abolish the current 2-year qualifying period for standard unfair dismissal claims. As I'm sure everybody knows on this call, that an employee cannot currently raise a claim for ordinary unfair dismissal unless they have had 2 years service under their belt. Now, the position of the government is that this is too long, and this creates too much insecurity for too many people. Although, as Richard pointed out earlier on, the government's own assessment of its impact assessment is that the justifications on that are not quite as clear at the moment as they could be. Now, since the manifesto was published and since the new government has taken office, the plan does now look slightly more nuanced over whether employers can have can use a sort of probation within the initial period of employment, and the answer to that in terms of the current proposals is yes, they will. The unanswered questions that we have so far is exactly what form that will take, although we do have parameters available to us. So next slide, please, Kirsty. So the proposed exceptions to this, first of all, to this is those who have not yet started work, and also those in what is called the initial period of employment, or the statutory probation period. So alongside the abolition of the 2-year point will be the introduction of what will effectively be an automatic or statutory probation period. I've put here that the current government preference for that is 9 months, although since these slides were written, we've had the amendment paper that was published yesterday that sets out that the government intend for this to be between 3 and 9 months. In other words, employers will ultimately be given the choice of whether that will be of how long that will be, but it will be no less than 3 months and no more than 9. This means that there is a degree of discretion on that, although realistically, if that discretion is available in the legislation, I don't think it's difficult to imagine that the vast majority of employers will opt for a 9-month initial period of employment. Now, the question then which is raised is what happens during that initial 9-month period or 3 to 9-month period. Well, first of all, the slightly wider availability for dismissal will only be linked to dismissals for conduct, capability, statutory illegality, or some other substantial reason. So just those 4 of the 5 standard reasons for fair dismissal. Redundancy protections will not count and will not be available to be sort of exempted from that initial period of employment. Redundancy protections themselves at the moment look like they will be a day one right. I say look like at the moment. We are still in the early stages of this. We're yet to have proper parliamentary debates on proposed amendments. We're yet to have Lord's amendments, things like that. That will change, but at the moment, that is what it looks like. I suppose the other question there is, does this mean that during the initial period of employment, people will simply be able to dismiss without process, as they're currently able to do in that first 2 years? The answer to that is almost certainly not. There will be some form of process that will need to take place during that 9-month period. At the moment, we do not know the details of exactly what that process will look like, but it is likely at the moment, we think, to look like or be similar to the old statutory process that was in place before the current regime. For those with long enough memories. So in other words, it will be something akin to the ACAS process for redundancies. There will have to be some form, presumably, of written consultation, of written notice, and some form of meeting or consultation before such dismissals can take place. Okay, next slide, please. So the consultation process, there is a consultation process running at the moment. It will end next week on the 2nd of December. And the areas that will cover at the moment is the length of the initial statutory probationary period, although that now from the amendment paper looks like there is a parameter on that now. What is the compensation regime for successful claims if there is dismissal during that probation period? That's going to be quite interesting because there will likely be satellite litigation that is launched as a result of such dismissals based on the process itself. How will the compensation regime be calculated? What are the safeguards to provide stability and security for businesses and workers during that probation, and how exactly will the ACAS Code of Practice on Disciplinary and Grievance Procedures work within that probation period, and how exactly are employees to be signposted in order to gain support to ensure they have proper recourse if they are unfairly dismissed during that period. So a lot of unanswered questions on that point. We're all going to keep our ears to the ground in terms of the upcoming consultation and next stages of the legislative process. So next slide, please. The next area I'm going to focus on now is the reform of 0 hours contracts. This has been another really prominent headline in discussions on the Employment Rights Bill. And again, this links back to a long-standing policy of the Labour Party to ban 0 hours contracts outright initially. Again, that's another long-term Labour commitment. And again, that has become slightly more nuanced since the 2024 manifesto publication, which then qualified that further to ban exploitative 0 hours contracts. Again, precisely what is meant by exploitative 0 hours contracts is yet to be seen. What it does look like is there will be a move away, and this is a trend that we've been seeing recently over recent years, from the flexibility that 0 hours contracts provide. The one-sided element is that effectively it was thought that this was flexibility on the employer's perspective, but not necessarily for the employees. The reason that there has been a move away from banning the 0 hours contracts altogether is that many people do find them genuinely helpful, and there has been mention of the words baby and bathwater together in terms of getting rid of them altogether. So people who require that flexibility because of family commitments, for example, or study commitments, may feel hard done by if they are got rid of altogether. Okay, next slide, please. So the key proposals on this and how exactly 0 hours contracts will be reformed is to offer employees guaranteed hours based on a regular working pattern over a fixed period of time. And the current preference for that is a 12-week reference period. Now, that will potentially change the status of an individual from a worker to an employee if that happens. But the key point there is this is an offer of guaranteed hours. It is not an automatic trigger. So again, that gives the option and that flexibility for workers who may rely on the sort of fluid nature of 0 hours contracts. The other key point here is the right to reasonable notice of shifts and compensation if shifts are cancelled or if they are moved at short notice. That will mean effectively that employers could still be on the hook for payment of a shift if it is cancelled last minute. We don't know the precise details of that. You're going to hear that phrase repeated quite a lot throughout this seminar, actually. We don't know the precise details of that. But again, it's something that we are going to be particularly focusing on over the coming months as consultation develops. Okay, next slide, please. So the consultation is what is happening at the moment. So the main consultation here that's currently ongoing is relating to agency workers. A lot, as you can imagine, a lot of 0 hours contracts are in the form of this tripartite relationship between an employment agency, an end user, and the worker themselves. Some statistics there. As of March 2024, there's around 400,000 agency workers in the UK. I must correct that. Actually, that's actually the correct figure. There is 900,000 agency workers in the UK. 140,000 of whom are 0 hours workers. So a couple of the questions there: how exactly will that tripartite relationship work in relation to the obligations that are kicking in? So if there are fixed hours contracts to be offered for people with regular working patterns over a fixed period, who exactly is going to offer that? Is it going to be the end user, or is it going to be the agency? And on a similar vein, whose responsibility will it be for the payment of compensation for short notice cancelled shifts? Those are all questions that will hopefully become more clear as the current consultation develops. A couple of points that were raised in the amendment paper that was published yesterday in terms of the cancellation of shifts. It looks like the tribunal will be given a fair amount of discretion in regards to how much compensation they're able to be awarded, but that will be by reference to regulations, to secondary legislation that will be published, depending on, and this is how the amendment paper describes it, on the seriousness of the matter. Again, that's quite a loose, quite a woolly term here, and we're expecting more detail to come out as the consultations and the legislative process develops. One final point that I need to make here, again related to the amendment paper, and this is more related to initial rights. The limitation period in terms of tribunal claims at the moment, as everybody I'm sure is aware, for the vast majority of tribunal claims. That limit is 3 months. The proposals in the amendment paper is to extend that to 6 months for all employment tribunal claims. Again, there's lots of questions that come out of that. How will this how will this work in the context of the early conciliation process with ACAS? Does that mean the early conciliation process will be done away with? That seems highly doubtful. Does that mean that that will be extended further from six months to, at the moment, the 6-week extension that is caused by the early conciliation process? At the moment, we don't know. Not particularly helpful, but we will be keeping our ear to the ground and communicating all we know as these processes develop. Okay, I'm now going to hand over to my colleague Kate, who is going to talk about the family-friendly rights amendments as proposed in the legislation.
Thanks, Adrian. Good morning, everyone. So yeah, I'm going to talk about the family-friendly changes and also some points around harassment. So family-friendly, there's been some changes proposed in the bill in relation to the qualifications, so who is eligible for these benefits. As I'm sure everyone's aware, currently for paternity leave, there's a 26-week qualifying period. So somebody has to work with you for 6 months by the qualifying week before they would trigger the right to leave. And it's proposed that that will become a day one right. It's also proposed that the paternity leave can be added to the end of shared parental leave. At the moment, strangely, if somebody decides to take shared parental leave, they then would lose their right to take paternity leave. And obviously, for some employees, there are issues there with one potentially is enhanced, but also in terms of potentially reducing the amount of time that they could take off in total. So under the bill, somebody could take a period of shared parental leave, so share that with their partner, and then at the end of that, choose to add on paternity leave if they wish to do so. Similarly, with parental leave, which is the right to take up to 18 weeks of unpaid leave for childcare responsibilities, there's currently a 1-year qualifying period, and that will become a day one right. Now, in terms of sort of impact for HR and for businesses, parental leave is fairly low take up because of it being unpaid. So the fact that more people will clearly be eligible for the benefit may not actually make a huge amount of difference given that it's a period of unpaid leave. Paternity leave, perhaps more so of an impact, but it is only a 2-week period. Therefore, the maximum, people are taking off is 2 weeks of statutory leave. It's not something that's probably going to have a huge impact. And again, paternity leave, the take up isn't anywhere near as high as perhaps things like maternity leave. So yes, there will be an impact, but perhaps not that substantial. Next slide, please. So also on the family-friendly side of things, bereavement leave, there is currently a right for parents to take time off as bereavement leave for 2 weeks in the case of the loss of a child. What the bill proposes is to introduce a compulsory bereavement leave for the loss of other people. They haven't currently specified who would be covered by that, but we understand and anticipate it's likely to be similar to the individuals who are covered by the law in relation to time off for dependents. So people who are close family members or who depend on the individual for care in some other way that are likely to be covered by the period of leave. Again, as with all of these things, that is proposed to be a day one right. And it would be a period of a week of leave. In terms of impact, there obviously is an impact in that employers will have to allow people to have this period of time off in response to the loss of a close relative or person who depends on them. However, lots of employers do offer some form of compassionate leave anyway, and there isn't a requirement that this is suddenly going to require employers to introduce a period of paid leave. So it may be an administrative issue. There may be extra absence that needs to be covered, but it shouldn't be at a huge cost. And it'd be interesting to see what the level of take up is, given that people often take other periods of leave in these situations anyway, such as sickness absence or holiday to cover time when they need longer periods of time off. Pregnancy and maternity, as hopefully everybody is aware, the rights in relation to individuals who have been on maternity leave, returning to work and the situation of redundancy changed earlier this year in April. And the current protection that was introduced was to say that if somebody is on maternity leave or has returned to work following a period of maternity leave, they are protected in relation to redundancy for a period of up to 18 months following the birth of the child. And what that protected period means is not that they can't be dismissed or that they can't be made redundant, but that if a redundancy situation arises, they effectively get to jump the queue in relation to any suitable alternative position. So if their own job is disappearing, they get sort of first dibs on any new position that may be available in that situation. What the bill is proposing is to extend the protection for those who are on maternity leave or returning from maternity leave. Now, the headline around this was to talk about preventing the dismissal of those on maternity leave and those returning from maternity. Except in certain circumstances. What the bill actually does is simply say that regulations can now be introduced to address other types of dismissals and how individuals may be protected for a particular period of time. So we don't know what kind of dismissals will be allowed, we don't know which ones will not be allowed, and we don't know what the circumstances will be. But we would assume that, for example, gross misconduct would still be something that can be relied upon, even if somebody has recently returned from maternity leave. But things like redundancy or business changes, such as some other substantial reason, things like that, or even perhaps capability, may be more difficult in that initial protected period when somebody has just come back from maternity leave. But it is going to be subject to additional regulations after the bill has been consulted on. Next slide, please. So linked to sort of the family-friendly statutory rights is flexible working. Now, what the government said was they wanted to make flexible working the default position, which suggested that everybody could, from day one, do whatever they wanted and demand flexible working on their own terms. What the bill does is far less than that sort of level. It's not hugely different, in my opinion, from the current flexible working regulations. It applies from day one, but the request situation already applies from day one. So we're already in a situation now where people can make a request to work flexibly straight away. So that's going to be the same. The request can only be refused on the 8 set business grounds. So you can't just say no because we don't like it, but you have to link it to one of the business grounds, which are things like inability to share work amongst other people, impact on performance, impact on clients, that sort of thing. So you have to have a good business reason to be able to say no to somebody's request. And those reasons are continuing to be as they are currently. What is changing is that there is an addition of a requirement of reasonableness. So at the moment, under the process that must be followed, the process followed must be reasonable. So there is a requirement to talk to the employee and consult with them about their request and your reasons for potentially saying no. And that process must be a reasonable one, but there isn't a particular element of reasonableness in relation to the decision making. And that is what's being introduced under this. So what the requirement will be going forward, if the bill is approved in its current form, is to reject on one of the 8 grounds and to then explain why such rejection is reasonable. Whereas now you could just say it fits within a particular ground and not necessarily have to justify it. In reality, I think most reasonable employers already did all of this. You tended to explain the rationale for rejection if you are rejecting a request by justifying why it's a reasonable decision, as opposed to just saying no because it doesn't fit within this particular ground. So I don't think this is going to make a huge difference in terms of the reality of it. The potential difference will be an increase in requests just because people are aware of this change. So when something is so heavily publicized, often employees become aware of it and then perhaps do think that it is the default position to do whatever they want. And you may see more requests that come in from day one with people thinking they've got greater rights than they had before. But I think the reality of it as currently drafted is that the process is not going to be that dissimilar to now. The reasons for saying no are not going to be that dissimilar. You just have to be able to explain it in a bit more detail and justify it. So there may be more to deal with, but it's unlikely to make a huge difference as it currently stands. Next slide, please, Kirsty. So the other area I wanted to talk about is harassment. So as hopefully everybody is aware, harassment is part of the Equality Act. It's one of the elements of discrimination. And harassment is unwanted conduct relating to a particular protected characteristic. Now, under the Equality Act, there are 9 protected characteristics, but only 7 of those are protected in relation to harassment, and they're the ones that are showing on the slide. So it's age, sexual orientation, disability, sex, religion and belief, race, and gender reassignment. Next slide, please, Kirsty. So the position at the moment is that as employers, you are vicariously liable for the acts of your staff during the course of their employment. So if an employee discriminates against another employee, harasses another employee, the default position is that you as the employer are liable for that, unless you can demonstrate that you've taken all reasonable steps to prevent it. In terms of third-party harassment, although the Equality and Human Rights Commission guidance says that there is a duty on employers to stop this, there isn't currently anything in the legislation which would enable an employee to actually sue you if you don't stop it. So if an employee is harassed by a third party, technically the Equality and Human Rights Commission could investigate you and could impose a fine and they could take action, but the employee themselves can't do anything about it. There was a provision about third-party harassment in the Equality Act, but it was removed, or it was decided not to implement it. So that is currently not part of the law. So it's a bit of a gap where you have a technical duty to stop it happening, but if you don't stop it happening, nothing really happens. What is going to change, which I think is going to be substantial, is the bill is introducing liability for that third-party harassment. And the way in which you'll be able to defend such an issue is to show that you've taken all reasonable steps to prevent it. So the same defence that you currently have available in relation to your staff harassing or discriminating against each other will be there in relation to third-party harassment. What we don't know is, well, what is that all reasonable steps going to be? In relation to staff and preventing staff harassing each other, we're often saying things like it's about having your policies updated, having staff trained, and being able to demonstrate that you've given the clear message that you don't tolerate certain behaviour. But obviously with third parties, you're less in control of that. So what will that look like? It was interesting in the poll that when we asked you about what steps people had taken in relation to sexual harassment, only 2% of you said that you'd done anything in relation to any third-party agreements. Now, I'm not saying that that necessarily is going to be a reasonable step or something that's required, but it's something that we think is probably going to have to be considered. So, have you carried out a risk assessment in relation to your third parties? A considerable portion of you, I think it was 42%, said that you saw third-party harassment as a potential risk area. So, what are the issues and what could you do in order to prevent that from happening? Those are things that are going to need to be documented in a risk assessment and then steps taken. And those steps might look like inserting clauses into supplier agreements or customer agreements to say what your standards are and how you will not tolerate your staff being harassed. Things like the notices that we see in pubs or on public transport about harassment may need to go into commercial agreements to say that you've taken all of those reasonable steps. But we don't know, and there hopefully will be guidance when this comes further down the line. But it's definitely something to start thinking about in terms of what the risk areas are, so that you can potentially avoid that liability. Linked to the third-party harassment and this all reasonable steps defence that you will need to be able to demonstrate to avoid it is the recent change in terms of sexual harassment, which hopefully everybody's aware of. Since the 26th of October, there has been a positive duty on employers to prevent sexual harassment specifically rather than harassment more generally. And the requirement has been to carry out reasonable steps to do that. And that is proposed under the bill to change to become all reasonable steps. So instead of having to do what is reasonable, you now have to do everything that could be reasonable. So it's a slightly higher hurdle if the bill is implemented in its current form. And that's just so that the two things fit together with the defence and the compliance with the preventative duty. Next slide, please. Finally, from me, just a mention of terms in relation to statutory sick pay. So there are two proposed changes. One is to remove the 3 waiting days. So at the moment, if somebody is off sick and their entitlement is to SSP only, they don't have any contractual benefits, then they will not receive any pay for the first 3 days and only get paid on day 4. And that will be going. So again, the theme being it's a day 1 right. As soon as somebody is off for the first day of absence, they will be entitled to pay. Now, obviously, the fear from employers is this leads to increased sickness absence. People that perhaps were only going to get SSP who think, well, I'm not going to take a day off because I won't be paid for it, may then take that day off instead because they are going to receive payment. So it could lead to an increase in sickness absence. Equally, it may lead to an increase in the odd day, but improve longer term sickness absence, where there is a danger of people coming to work when they're not well because they're not going to get paid, spreading their germs to everyone else, coming to work unwell for a few days, realizing they're actually not well enough to do so, and then going off for a longer period of time. So there is a bit of a balance, but likelihood is there may be an increase in the number of odd days absence. The other issue that's being amended is the removal of the lower earnings limit. So at the moment, anybody that earns under £123 a week doesn't get statutory sick pay, and that is being abolished. So that everybody will get something. And for those that earn under the statutory payment, they will receive a percentage of their salary, but we don't yet know what that percentage will be. Okay, I'm going to hand over now to Kirsty, who's going to talk about firing and rehiring.
And good morning, everyone. Apologies because you've got me doing the slides and talking, so I failed a bit there. But here we go, fire and rehire. So in respect of what the current situation is, it's quite a handy tool for employers where they are seeking to do a variation of contract with staff, and those staff who don't agree the contract variation, subject to consultation, you can effectively serve notice to dismiss on the current terms and then re-engage on the new terms. The proposal, however, is to remove this practice, making it automatically unfair to dismiss for this reason. So that will apply equally where an employee is being dismissed for not agreeing a variation of contract, to then either recruit or pass the terms and duties over to another member of staff to carry that out. And factoring in the day one unfair dismissal rights, it will have a significant implication. The purpose of the bill is to create a fairer balance between employers and employees with job security and better working conditions, and that's why this has been proposed. There are exceptions where employers will be permitted to effectively enforce a unilateral variation if an employee disagrees. But that's got to be where the business is effectively in dire financial straits, so it's likely to fold, and therefore the fire and rehire option is essential because there's no other way to effectively avoid the collapse of the business. So the wording of the bill is proposing that one exception. That's not the end of it though, however. So if the business can overcome and show that there's this financial reason for needing to press ahead with the fire and rehire, the tribunal must still then look at what consultation was carried out with the employee. If there is a recognised trade union, then it's looking at what consultation has been carried out with the trade union, the recognised trade union. If there's no recognised trade union, then it's looking at what consultation may have been carried out with any other employee forums or staff forums. The tribunal will then also look at what is being offered to the employee in return for agreeing the variation. And then if there are any regulations made by the Secretary of State, they'll be reviewed as well. So what is varied? Varied is effectively changing a term that wasn't the original term the employee was employed to work under. So the financial dire straits, for want of a better term, is going to be quite a difficult defence for an employer to run. And what is this going to mean for employers moving forward? Well, consultation. It's going to be harder to potentially get amendments through. And in terms of the timing needed for it as well, you may need to sort of factor in the time to go through a consultation period, particularly where there are recognised trade unions involved or staff forums. It will create a reduced flexibility on businesses to be able to apply quick changing, enable businesses to adapt to quick changing needs. and it will make it harder for businesses to implement changes to stay competitive. So an example at the moment is where we've got the increase in the employer national insurance contributions. Some businesses may find that they then have to cut back on other benefits. And so presently, they may be looking at using this scenario to make some changes. But moving forward, if the current proposals proceed as planned, then this isn't going to be available and it could be a costly exercise. With the increased emphasis on the use of trade unions as well, this is going to potentially cause risks of increased industrial action and disruption to business operations. So it's very much going to be the need to gain employees' consent, which can then equally cause increased administrative and legal burdens and costs. So equally, it will be important to have very well drafted variation clauses in the contract, so that in the event an agreement can't be made, the contract itself provides a provision to allow the employer to make those changes. So at the moment, as both Adrian and Kate have said, we don't know for definite what changes will be enforced, but if these proposals with the current fire and rehire restrictions do take effect, it's definitely, you've got time to be having a look at what your contract clauses are and getting those variations put in place. The other thing that I'm here to talk to you today about is the changes on collective consultation. So by way of reminder, those who are proposing to dismiss 20 or more staff over a 90-day period have a duty to collectively consult. So that's the minimum consultation period between either 30 or 45 days, subject to how many you're proposing to dismiss. Proposing to dismiss can also include, again, as a reminder, those where you're looking at contract variations. So if you've got a large number of staff and you want to change their contracts and there's risks that they're not going to agree to them, you're going to be caught with the collective consultation trigger. So at the moment, the definition is looking at one establishment. So it can be a case where you would just simply look at a branch, a workspace, a shop in isolation, but the amendment is that the word one establishment or single establishment is removed. So the impact will then mean that employers will have to look across the entire business to, when they're assessing the need for redundancies, to ascertain whether then collective consultation will be triggered. In addition, if employers presently don't follow with their obligations on collective consultation, employees can be awarded something called a protective award. So that's effectively 90 days pay as a punishment for the employers not going through that exercise. And the proposal is currently twofold: either to increase that from a 90 days to a 180-day payment, or it will be to effectively remove the cap. So there's unlimited compensation that could be awarded for employers who don't follow that process. So what does this mean for employers? Well, there is one positive, and that is that the ambiguity has been removed, because it's often quite the case where people will scratch their head and say, well, is this one establishment or is it not? So that's the only sort of positive that's being taken away from the employer's perspective. Obviously, very good help for the individual employees. But it is then going to mean that, on the other hand, it's going to be significantly harder to go through a redundancy process because of the costs involved. And it's not just the administration costs. There could be legal burdens on employers, especially if the need to conduct multiple consultations is taking place simultaneously. And it's certainly going to be a lot more onerous. Again, for those who have areas which are caught by trade unions, there could be further increased risks of industrial action, business operations disruption, and potentially harming employer relations. So in terms of looking at what the plans are when any restructures or redundancies are being planned, a lot more thought is going to have to go into it, a lot more time is going to be factored in due to the need of having to look across the entire workforce. So that's, I'm conscious that we want to get through some questions and answers. So that's come to the end of what I wanted to say to you. And I think the plan is now to have a look at what questions come in, because I was seeing that there were some in the background.
Thanks, Kirsty. And thanks to everybody. Thanks to all three of you there. A lot of food for thought. I think I made a really good point there, Kirsty, I think, around fire and rehire. And whilst we, as you say, don't know all the detail yet, I do think having a look at contracts around flexibility clauses and general flexibility clauses, that you see that say we can make reasonable changes to your terms and conditions. As we probably all know, those are pretty ineffective, and you can't rely on those to make material changes to contracts. So definitely having a look at contracts to try and build in some more specific flexibility, whether that's to changing hours of work or locations or benefits, is probably something definitely to give some consideration to. So yeah, questions. Kate's already answered a few in the Q&A box, but we've got a few more we can cover. Adrian, Kate, Kirsty, do you want to chip in and try and answer any of those questions that are in the Q&A box at the moment?
Sorry,
go
Kate,
go on, Adrian.
I was just going to say that the second point here, which is an anonymous question, as redundancy will be a day one right, will those with less than 2 years service be entitled to redundancy compensation? The answer to that, I think, is it would appear so. Yes. That would equalise the rights proportionately between those with those with two years service and those from day one. So yes, it would assume so. It's going to be interesting to see how that compensation is calculated for people with significantly less than 2 years service, because at the moment the statutory redundancy payment is 1 or 1.5 weeks pay per completed year of service, depending on age. So if somebody has less than 1 year completed service, how exactly is that compensation going to be calculated? The rather frustrating answer is we don't know at the moment, but that should become clear as the legislative process develops.
It's possible then, Adrian, presumably, that someone with 6 months service might not be entitled to anything at all.
Maybe not, but we don't know at the moment. That would mean that even if the redundancy compensation is not due, there could still be a claim for potential unfair dismissal. But then again, there's another question about what the compensation would be for that, for somebody with a length of service which is quite so short. So a lot of possibilities there, but the short answer is that it would appear that yes, there would be some compensation available, but that's not yet stated specifically in the proposed bill.
Kate, you were going to answer a question.
A couple of questions in there about the third party harassment, and one question around what about the sort of the notice that potentially could be put up. Somebody's asked the question, where can we find one? I don't know the answer to that, but what I would say is it needs to include clearly what you will and will not accept, and as clear as possible. So if you can list the characteristics, we won't accept our staff being treated inappropriately, badly, etc., in relation, related to any particular characteristic, but also, what will the consequence be? Because all very well just saying we don't put up with it, but what does that mean? If we're talking about things like commercial agreements, there may need to be a clause that says, if you do it, we'll terminate the contract. If we're talking about members of the public or people that you need to put a notice up for, what's the consequence going to be? Are you going to remove them from the premises? Are you going to stop them coming again? What will it be? So some detail about, a bit like the trespassers will be removed, that kind of clause that says, people will be removed if this happens, or even that potentially the police will be called. So something that makes it clear that you will take it seriously, as well as saying you won't put up with it.
Thanks, Kate.
I've seen one about a variation of contract query. So if I jump in on that one. So the question is, does a variation of contract cover changes and additions to a job description? So it's, if you look at it, of what were they originally employed on versus what is it that you want to put in place? If that's a change, then ultimately, if they don't agree to that change and you want to dismiss them for it, then yes, you're going to be covered under these present reforms. If it is relating to changes to a job description, then factoring, if you've got the employee's consent, then that's okay. This is only going to be in the events where you don't have the employee's consent, and therefore you've got to look at what are your options. You're no longer be able to use the option of dismiss and re-engagement, fire and rehire, as it's termed. So it's just about working with your individual employees to effectively get them to agree. But yes, it will cover changes to job descriptions.
So that's presumably a good example where you might want to build some flexibility into the contract around being able to make changes to job descriptions without the employee's agreement. Yeah.
There's an interesting question in there about SSP, and somebody saying, what can we introduce, or do we anticipate being able to introduce sort of a process or policy to try to mitigate that impact? Yes, I mean, the things in the question, could we have a procedure about back to work interviews and self-certification? Yes, and I think those are things that probably people ideally should be doing in any event. With these odd day sickness, it's potentially easy for people to take absence when perhaps they're not as sick as they're suggesting. But also, odd days can be a pattern which can be picked up. So return to work interviews ideally should be happening after every period of sickness absence, not just long-term absence. And it's perfectly reasonable to ask people to certify that absence for the first week. After that, they can get a medical certificate. It's unlikely to be able to require someone to get a medical note any earlier than the current position unless the law changes, because doctors won't provide it in that first period because self-certification is currently available. But that doesn't mean you can't ask somebody to self-certify from day one and carry out some return to work interview, which links into their entitlement to be paid.
Excellent.
Okay. Yep, I've just noticed there's a few questions here in relation to the 0 hours contract and guaranteed hours point. Julie and another anonymous attendee and Mick have all raised points on this. Julie's mentioned that she works for the NHS and there are bank workers that are used significantly across the whole organisation. And if these are banned, the NHS would not cope. And I think it's important to keep in mind here, although there has been talk of banning 0 hours contracts, the proposals clearly indicate that they will not be banned as such. I suspect, and I think it's pretty reliable, it's reasonably likely that 0 hours contracts will still exist as a result of these changes. There will likely be fewer of them due to the fact that individuals are being given the opportunity to effectively convert 0 hours contracts into fixed hours contracts by way of the guaranteed hours, but that is not that's not automatic. It is only an option, and plenty of people, I think, and I imagine this would be the case of people working in the health and the care sector, will hold on to the flexibility surrounding bank staff and 0 hours contracts because they are mutually beneficial in many different contexts. The anonymous question was, if an employer does not offer guaranteed hours contract when they are entitled, when they should, can an employee make an ET claim? We expect yes, that will likely be something that can be claimed. Again, in precisely what form, and that is yet to be that sort of detail is yet to be fleshed out. But anything whereby there is a specific right being incurred on obligations being incurred on employers, and for breach of those obligations, such as an offer of guaranteed hours, and yes, we would expect that to be actionable in the tribunal.
I'm conscious of time. We're sort of just getting to 11 o'clock. I think we're probably happy to stay on, try and pick up another 1 or 2 questions, and then we might have to bring things to a close. Anybody else got any other questions they want to try and address from the chat?
I've seen there's a couple about collective consultation. So there's an anonymous question saying, regarding one establishment, will this have to include offices that are outside of the UK? So if there's a small office in France or Ireland, will the employees need to be included in considering redundancies? So the The wording is just a case of removing the one establishment, so it will be across the entire business. However, factoring in that employment laws differ between the UK, Ireland and France, my personal opinion would be that it would just relate to those within the UK. Because if you look at what's happening in a collective consultation process and what's happening in any redundancy process, you're looking at alternatives, so that ultimately dismissal is the last resort. And realistically, would staff accept a role in Ireland or in France as an alternative? It wouldn't be a suitable alternative because of the travel. It will be interesting to see if there's any discussion that comes out of the consultation about it being outside of the UK, but I certainly would expect it from the way our laws are governed to be within the UK. And then there was another one, if I can quickly find it while I've got it. It was, yeah, so perfect. So from Lindsay Wilkinson saying, is the need to consult with all staff across a group of establishments about a change in one establishment if 20 or more are affected? Or is it if 20 or more people are at risk of redundancy across the whole group that you need to consult in the one establishment where changes are needed? Is it a change or just redundancy? It could be either a change or a redundancy. If you're looking at a change, what's going to be the implication? Are more than 20 people going to be affected by the proposed change? And if so, is there a likelihood that they could reject the change and say we won't agree to it? So then collective consultation will kick in there, because you would potentially have a proposal to dismiss, albeit factor in now the risks that are going to come from fire and rehire. But then if it is a redundancy situation, then yes, you're ultimately looking, I think the best way to look at it is, how many people are going to be affected by the change or the restructure or the proposed redundancy? Are you hitting that 20 plus mark? If so, then you'll need to follow collective consultation to avoid a potentially very expensive protective award if the cap is removed.
Great, thanks. I'm conscious it's 11:05, so we probably might need to call it a day there in terms of questions. So apologies if we haven't got to all of your questions. If anybody does want to get in touch with us separately for us to help with something, please do drop us a line. We did have a question about the recording. I think what we're planning on doing is circulating a follow-up email to this session where we can provide a link to the recording. And also just wanted to mention our LinkedIn, RWK Employment LinkedIn group. So if any of you, I know plenty of you on this call are already members of that group. If anybody is interested, we push out quite a lot of content around employment law changes and things like the Employment Rights Bill. So please drop any of the speakers a line on LinkedIn, and we can get you or make a request, and we can add you to that group. I think that probably brings us to an end today. So thank you everybody for listening for so long, or so many of you staying on the call and asking some really good questions. We're going to have to go and scratch our heads about some of these a bit further, I think. Plenty of challenges for employment lawyers and HR teams. And we will, I'm sure, be running some further sessions on this bill as it progresses, because as we've said, no doubt there will be some changes, and there will definitely be more detail as the months go past. So thank you everyone, and have a good day.